Hey everyone, and welcome back to my channel. So in today's video we are going to continue from the chapter 4 of the ICAN Foundation Level Business Law exam, and the topic is Insolvency Law. And we're going to be covering the course content, which has to do with the purpose, the um, types of insolvency. We'll talk about a receiver. We'll talk about the agency of a receiver. We'll talk about who a receiver is, their duties, the powers they have, and insolvency practice. We'll also look at scheme of arrangement, compromise, and netting, and then we'll take a look at the differences between fixed and floating charges. And after that, we'll call it a night. See, when we talk about insolvency, when it's in the case of an individual, we can actually use the word bankruptcy. So for company, the right word to use is insolvency. And what does insolvency means? Insolvency is more or less like is a situation that occurs when a company is unable to pay its debts. And there are two types of insolvency. We have the corporate insolvency and we have personal insolvency. You get, so basically that is the idea for insolvency. Just liking it like an individual now that is bankrupt, like doesn't have money to pay its debt or cover up for its liabilities. So it's same way for a company, but this time it's not called bankruptcy, rather it's called insolvency. So there are tests for it. There are tests to insolvency, which is recognized by the Companies and Allied Matters Act. So when do you say a company is insolvent? First is when the company is unable to pay its debt within 3 weeks after a demand for payment. Let's say you as a creditor, you went to meet a company and then is unable to pay your debt after 3 weeks of meeting them. Then that's one test to show that the company is insolvent. So um, there are different other tests to show, some of which is a situation in which the company's liabilities exceed its assets. So if what they are owing is more than what they have, it's common sense to know that they are insolvent. Okay. The C here says a court's determination after taking into account any contingent or prospective liability of the company that the company is unable to pay its debt. So this is if what this one is saying is if the court determines, after looking at every contingent and prospective liability of the company, and they find out that yes, the company is unable to pay its debt, then the company is then considered as insolvent. Okay, so procedures um for companies in financial difficulties, like formal procedures for it. Let's say a company is in financial difficulty, what can they do? So first thing they can do is that they go into receivership, or they close down, which is also winding up, or they fall under the schemes of arrangement and compromise, and we'll be talking about these three things. Now let's look at receivership in a nutshell. Okay, receivership, according to what the study pack says, is an alternative to liquidation, where a company is in financial difficulty. Okay, and it is the right of the secured creditor to appoint a receiver to manage the company's assets that are the subject matter of the creditor's security. And there's a place I highlighted. Receivership involves appointing a person to either sell or collect any income arising from the asset subject to the charge in order to satisfy the outstanding debt owed to the creditor. So more or less, it's just that moment when they want to liquidate some of their assets to settle debts. Then a receiver is appointed. A receiver is appointed either by the court or by the creditor to the company. You get, so let's look at the 4.3.2 appointment of receiver by the court and out of court. So we must understand something, that like this question always pop up in the business law multi-choice question, and that's why I highlighted it here. So we should understand that a receiver so appointed is an officer of the court. Yeah, it's an officer. They are officers of the court, so we must know that one very well. And duty of a receiver, the different duty of a receiver. First, when a person is appointed as a receiver of a company, it is expected that he shall, subject to the right of prior encumbrances, take possession of, protect the company, receive rent and profit, and discharge all outgoing in respect thereof, and realize security for the benefit of those on whose behalf he is appointed. But unless he is appointed manager, he does not have power to carry on any business undertaking. So, in a nutshell, to explain this, when a company have different properties, yeah, um, it's like when he has liquidated those properties. Let me just use this example. When he has liquidated those properties and he wants to clear, or let's say he wants to pay the creditors, yeah, you should know that some property have priority over others. Like there are some there when you talk about prior encumbrances, you should understand that in the settlement of debt there are properties that have priority over others, and he needs to understand that too. He needs to understand, put that into consideration, that every of his dealings is subject to prior encumbrances, and he will take possession of and protect that property. Even if it involves protecting it to his own life, he must protect that property, and then he can receive rent and profit, and then discharge all outgoings. But the only thing that a receiver cannot do is to carry on business or undertaking. Yeah, he does not have that power unless he's a manager when appointed. So, liabilities of receivers and managers on contracts. A receiver is liable personally on any contract that he enters into, to the extent that the contract provides expressly. So let's say, for instance, if he enters into a contract in discharging his duties, he's actually entitled to be to is actually entitled to indemnity for the liability incurred. So when he incur any debt, or so any, yeah, even incur any expense, he should and is entitled to an indemnity. Okay, so but a company is placed in receivership, so we should know that the principal sum borrowed by the company or the interest is in arrears. Now these are like the styles to know. Okay, we get to learn that this company is placed under receivership, and then you're asking what happened, why. You just know that first is the principal sum borrowed by the company, or the interest which the company had borrowed is in arrears, they are yet to pay it, or the security of the property of the company is in jeopardy. Yeah. Also, the company fails to fulfill its obligation imposed on it by the debentures or debentures trust deed. You I think this particular C is self-explanatory on its own. If you read down through, you would also grasp reasons when to say a company is placed under receivership. Yeah, so let's just go straight to the powers of receiver slash manager. Okay, we should try to get this thing. Sometimes the multi-choice question use simplicity, so we should know that yes, you are still referring to same thing. Remember earlier I said a receiver, he shall, subject to the rights of prior encumbrances, take possession of, protect the company's property. Yeah, like he can do all those things which I had mentioned earlier, but the only thing he cannot do is to carry on business for the business, for the company, I mean to say. So in this case now we're looking at the powers of receivers and manager. So again, you can, if you see the A part, say part to take possession of, collect, get into property, for that purpose to take such proceedings as may seem to him expedient. So it still borrows from the duty of a receiver, and then the addition to it is that he can do these remaining things, which are to use company seal, to endorse bills, exchange bill of exchange or promissory note. Yeah, to do all such things, including carrying out of works as may be necessary for the realization of the company property, to carry on business for the company, to establish subsidiaries. So these are other um, powers attached to a receiver slash manager. So now the agency of the receiver. Okay, at common law, a receiver manager appointed by the mortgagee is deemed to be the agent of the mortgagor, so that the mortgagee may sue the mortgagor for any loss resulting from the negligent act or omission of the receiver. I'm trying to remember this case between Medford versus Blake. Yeah, Medford versus Blake. Just recently I was reading on it, but I'm trying to figure it out now. Okay. Okay. Let's just go for that. Again, please, if you've gotten to this point, I would plead that you subscribe to my channel, you turn on the notification bell, and also, as a way of supporting me, you comment on how this series has been helpful to you. Yeah, you can also reach out to me on WhatsApp. Like I said earlier, everything I do on this video is in preparation for my ICAN exam in May 2024, and I've been reading and then summarizing what I've read, even the researches I've made, putting it in a video form and sending it out to you guys, so you guys can pick one or two things that will also help you in your own reading, that you can actually use to understand your own reading better. And if you don't mind, if you're open to discuss this course, you can actually reach out to me on WhatsApp. I'll be very willing to discuss or chat about this business law course with you, right? So let's just move further. So duty of receiver and manager. It is the primary duty of the receiver manager to take possession of, protect the property, receive rents. Again, we are repeating those things that we have said earlier. In addition, a duty of care is imposed on him, and what other unique thing can we pick out from this again? Okay, let's look at the last paragraph. It said, in ensuring that the receiver manager is prudent in managing the property or undertaking of the company, Cama provides that, except otherwise provided, he shall be personally liable on any contract entered into him, and may be indemnified only where he entered into the contract in the proper performance of his function. So indirectly, if he acts outside instruction or outside his functions, he and then enters into contract, he will be liable for that contract, and there will not be any indemnity. So anything he does in performing his function as a receiver or manager, then he is entitled to be indemnified.